Alrighty. So the big topic for today's training session is obviously kind of timelines, timetables, but also just answering some questions that I've seen kind of pop up periodically in the contract process, things to pay attention for, things to watch out for. So first thing I want to talk about is this timeline sheet that I have made that is in app files for anybody that is a visual person and likes to see the dates. So ultimately, we have executed contract date. So for those of you in the room, what is an executed contract date?
It's the date that both the seller and buyer sign the contract.
And there's another key part to that: signed and delivered.
Delivered to the
Right.
title company.
No, not to the title company, to the respective people.
Oh, respective.
Right. So let's just, again, in today's age, we're using a lot of e-signatures. You have a seller, or actually, let's flip it. You have the buyer. You write up an offer signed by the buyer. You email it to the listing agent. The listing agent then says, yep, you got a deal. It gets signed, and then you don't hear anything that entire day, and then the next day you get it back signed by all parties. When is the executed contract date? It's that next day. It's not the day that that listing agent told you got a deal. It's when it's signed and delivered. You are an extension of the buyer, so it's when you physically receive or email, you receive that email with that executed contract. You are an extension of the buyer. So that again comes into play if you ultimately have to like snail mail an executed contract to the buyer. It would be when you receive it, Joe, not when they receive it via mail. Yes.
So then the date on the contract, what role does that play?
So that starts the entire process. Okay. Correct. So ultimately, the date and what Joe is saying too is ultimately that's the date where the last party has signed and or initialed. So is a contract fully executed if there is markings on the contract that haven't been initialed by all parties?
No.
No. Right. That is correct. If you strike through something, all parties have to initial it. That contract would not be executed. You don't want to play the game of letting that go on either. You know, I get agents that ask me, or even sellers or buyers, they think they're slick. And they're like, well, I didn't sign that. We went 3 weeks down the road and now I want to back out. And look, I can get back out because this wasn't fully executed. Well, that can go to a court of law. Ultimately, they performed, whether they ordered inspections, whether they submitted escrow, they performed on that contract with that fault being there. So you don't want to play in that gray area. If something gets changed with a strike through, please, please, please get your party to initial it.
I have a question.
Yes.
If, just say a buyer's name was written on the contract incorrectly,
Mm-hmm.
and it was strike through and was spelled correctly, and both buyers, husband and wife, sign that, does the seller have to sign it as well?
Yes. Yep.
Initial it.
Yep. Yep. Also, anything that is handwritten or typed on a contract overwrites anything that is pre-printed on it. So if in the contract it says loan approval period is 30 days or inspection period is 15 days, and in the additional terms you write something else that changes that, inspection period is 10 days, it's 10 days. That handwritten part supersedes whatever is pre-printed in it. So
Even if it's
anything,
not struck
even
out.
if it's not struck through. Anything that you write or type on that contract is basically held at a higher level than anything that's pre-printed in that contract.
Hey, Wayne.
Yes.
Wayne, where is the most reliable place? Now, let's say you're down the road, okay, and you are writing an addendum or something is happening and you need to know the executed contract date. And I think, you know, we tend to go and look at the last date signature, right, on the actual contract. But if
Right.
it was, you know, delivered the next day or, you know, usually I think we remember if we've got something going on. But anyway, you've got the gist of my question.
Absolutely. So what me personally I would do is I would put it in your section here. So you can put something like this. I'm using a random date here. And so now you see on this line here, you have it right here. Reason why I like that is if I'm bouncing between forms to type something new up, like an addendum, because our blank addendum does say executed on what date, instead of jumping between all these forms over here trying to figure that out, scrolling to the 14th page, I have it right here. You can also do it here in the file information. Remember, we can add sections here. So you have the ability ultimately to do all different kinds of templates that are pre-filled here, or you can actually do a new section here.
Laura, there at 10. So that's fine.
Yeah, we're going to stay out of the back room.
You can sit here.
I'll sit up here.
So,
Might have something to say.
I thought this was your seat.
That's my corner. This is another corner.
now I've added that. I see this right here, Judy. Another place that I can do it. Does that help you, Judy?
Can you roll your cursor around because I don't see it?
Do you see, this is where the section, oops. Right
Okay,
here in the
I see it
file
now.
information. Yep. So we
I
put
see
it
it.
down here when we did the add section right there.
Right.
And then we also if you ever want to change the notes section here, we put it here as well. And that's by clicking this blue edit button right here.
Yeah, that one I got. The other one was a new thing for me.
Yeah.
Okay, thank you. That is very helpful.
Alrighty. I'm going to flip over to something for fun here. We'll see how good you guys are. So, who is, oh, I think we're good now. Here's my little trivia question, well, not trivia question, but real estate question. So, how many days do you have to deposit escrow? Feel free to answer it in the chat as well.
3.
Lindsay, what's your answer?
Either 3 or the day that, that's it. It can either go with the offer, 3 days, or there's a spot that you can put, right?
Listen, you're answering. Joe, what say you?
I think the maximum is 3 days, but the preferred is execute within 24 hours.
Tom?
It is all depends on what is stated on the contract.
Hey!
That's basically what I said.
It was.
Oh, wrong one. I forgot. Whatever's written on the contract. So you can put 27 days on the contract. You can put, so it's if left blank, 3 days is the one option. And the other option is will accompany. So again, I'm just kind of keeping you guys on your toes here.
What's the price is like?
I want.
Yeah, right? You guys need pies.
Here, I'll grab some chocolate.
So when we look at an as-is contract when it comes to the escrow, right here it says a company's offer. So again, meaning already with the offer, not the executed contract, but the offer, or is to be made within. And then if you leave it blank, it's 3 days. I have 3 days pre-printed on mine, so it already fills it in. But that's just the standard procedure. It can be different depending on that. One reason I wanted to bring this up, I think it was Mark Allgood was having some issues of getting escrow submitted in, and it kept happening. So what we ended up doing, who is not muted? Okay. Is we countered back and said escrow needs to be delivered with this offer. That was the seller's counter. So we didn't sign anything yet. We literally just countered back and said the escrow check needs to be made with the offer. So we already have it in hand to review. We're not accepting anything. We're not putting it into pending status, any of that stuff until we have that escrow. Following suit with that question, when do you mark a property pending on the MLS? Joe?
When the contract has been signed and delivered.
What say you?
I say when it's signed.
What say you?
Signed.
What say you?
Signed and delivered.
Signed and delivered. Correct. You don't wait for escrow to be submitted before you pen a contract. You don't wait anything like that. Our MLS policies and procedures states when you have a signed and executed contract is when you pen. And that is a black and white hard fast rule. You can't, even if you write in the contract, will not be pended in MLS until buyer does inspection. Our MLS does not care.
I've done that before.
Right, you'd be violating MLS policy and procedures once it is signed. Now, there is the ability to do pending with backups on it. Right, we have that status in MLS. Everybody familiar with that status? However, here's another fun question. What document is needed in our MLS to mark it as pending with backups wanted? Do you know, Lindsay?
Kick-out clause?
A kick-out clause. All right?
Yeah, she's like a ninja today.
Correct. That is good. So a kick-out clause is required for us to put pending with backups wanted. So the next question would obviously be, what is a kick-out clause? Am I right? Well, we have one in app files. So I'm just going to read it real quick for everybody to understand. But it says, seller will have the right to continue to show the property and solicit and enter into a bona fide backup purchase contracts with third parties that are subject to the termination of this primary contract. Upon entering into a backup contract, seller will give buyer a copy of the backup contract with the third party's identification and purchase price information obliterated. To continue with this primary contract, buyer must make an additional deposit of blank dollars to escrow agent within 3 days from receipt of the backup contract. By giving the additional deposit to escrow agent within 3 days, buyer waives all contingencies for financing and sale of buyer's property, and the parties will close on closing date. The additional deposit will be credited to buyer at closing. If buyer fails to timely make the additional deposit, then this primary contract shall terminate and buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. Does everybody understand what I just read?
Yes, but I have a question.
Absolutely.
Do you still do a cancellation and release?
You always do a cancellation and release. And we'll get to why here in a second. We have it on a flashcard. But yes, you will still do a cancellation and release for that. So ultimately, there are some nice things that this obviously does for you. And there are some things that you want to make sure your seller understands. Every time I have pulled this form out, and it has not been a lot of times, guys, the buyer basically says, no. You're going to accept the offer or, I'm not going to continue on. So it's the one in the hand, two in the bush concept here. Seller may absolutely love this idea. Like, yeah, that sounds great. Absolutely. And then you say, we may lose the buyer that you currently have who is quote unquote ready, willing, and able, depending on the circumstances, to purchase your home. Are you sure you want to continue doing this? If they say yes, then obviously you have your answer and, put it in front of the buyer and see what happens.
I have a
But,
question.
yeah.
So when you're negotiating, seller says, I come back at 200,000, buyer accepts that. Or no, excuse me, buyer says 200,000, seller says, okay, I accept that, but you're going to have to sign this kick-out clause. That gets presented to buyer. Buyer has the option to sign that, knowing what the additional deposit will be if
Right.
another contract.
Correct.
So, okay, so say he agrees to that.
Mm-hmm.
It's $3,000 additional deposit.
Right.
They're under contract. After inspection period, whatnot, there's another offer that comes in. And
Bona fide backup offer now.
Okay.
Yep.
So now that gets presented to seller. Buyer is aware that there is another offer, and now he's got,
The backup offer gets presented to this buyer number one, primary buyer. They see the backup offer, but they don't see the purchase price and they don't see the names. But they see that contract. They then have to decide, I want to continue moving forward, so I'm going to put the additional escrow money in, and I waive all my contingencies. So if I had a sale of property contingency, that's now gone. If I had financing contingency, that's now gone.
puts the buyer in a corner.
Oh, 100%. Yeah, absolutely. This is something that buyer number one is not going to be very appreciative of because
But
of
he
that
agreed
backup
to it.
offer. But he agreed to it. But he can also at that point say, I'm out. Then the backup offer now gets put into primary position. That's how that works.
Okay, so say he agrees to it, yep, here's the additional 3,000.
Yep.
The title company obviously gets this kickout clause, and then everything gets settled on the Alta, and you
Correct.
just make sure that that's all there.
Yep.
Okay.
Yep. And obviously the additional 3,000, I mean, it says it's going to be credited to buyer at closing. It's not adding to the purchase price or anything. It gets used for that same purchase price that was original. It's not more money. You're not buying it for more money. It's just coming off the top then. Jim, were you gonna say something?
It's a first right of refusal, isn't it?
Just with a couple of strings attached to it ultimately at the end of the day, because you have to waive your contingencies. Now, this could be $1. I mean, you could literally put $1 here if you wanted to. The dollar amount thing is not, to me, the big kicker. It's waiving all contingencies. Now, with that being said, again, this is a legal document created by the Florida Association of Realtors. We're going to take a step back and go into the real world. When we mark something pending with backups wanted, it doesn't have the same effect as an active listing. So just be aware that there are a lot of buyers, even when they see pending with backups wanted, they don't want to go through they don't want to be a backup. They don't want to do it. So it's not this instant, we're going to get loads of backup offers because we marked it as pending with backups wanted. So again, my conversation and my thought process is this offer good enough to take and put it into pending status? Are you satisfied with the numbers, the closing date, the terms, all of that? This is something that may come out in a pinch here and there, but it's not going to be the primary conversation I have. I just want you guys to be aware of this tool, because also on the flip side, I had a listing agent who had no idea about this form and then was very confused at how it all works when it was presented the other way. So.
I wonder if Turner has one of those, because it says backups accepted on that one.
Yeah, our MLS requires that.
Okay. But she's
To
not on
market.
Stellar.
Yeah, Stellar's a different animal. I've been told Stellar, you can write on the contract, won't go pending until after. I mean, you can, Stellar has a lot more leeway in that sense than our board does.
So does this have to get uploaded into the documents on MLS?
No, it does not have to be uploaded in the documents on MLS. Nothing has to be uploaded on documents on MLS too, either. That's not a requirement. However, it makes everybody's life easier if you put the lead-based paint on MLS already, the seller's disclosure on MLS. It just saves that step of you potentially forgetting to send it to the buyer and or whoever, seller, whichever way you're representing it, so on and so forth. So I always recommend putting it on Stellar, but it's not a requirement. Or, putting it on MLS, but not a requirement. All right, let's hop back to our flashcards. Next question. Does commission go on contract? Joe?
Does commission go on contract? Percentage of commission, yes.
No.
No.
I guess it can, but generally no.
I guess they can, but generally no.
Oh, boy.
I'm going to go against everything Jim just said. I keep doing that.
No.
No.
Oh, Jim!
I've seen it on there.
I've seen it on there. I've also seen people get absolutely ripped apart because it's on there. So my big thing, who signs contract? An as is, for sale, purchase contract. Does that have anything to do with commission?
No.
Do the buyer and the seller negotiate commission between themselves?
No.
Right. Doesn't belong on a contract.
Separate addendum. Yeah.
Separate addendum signed by all parties too.
That wasn't the question, though. You said, go back to your question.
Yes.
Does the commission go on a contract?
Correct.
I guess it is
Right.
absolute.
Yeah, the answer is no. Just don't do it.
I see it on
Yeah.
contracts all the time.
I see it on contracts all the time. I'm currently dealing with one on the contract, and it's $1 million contract, and they're trying to negotiate the commission on the contract. So, I'm going to get that call, literally say, hey, we have a co-broke in MLS that's been sent to you. You don't just put it on a contract, because here's the other thing that I've heard about. Luckily, it hasn't happened in this office. Let's just say it goes on the contract, and then it gets missed. Buyer agent tells the title company, well, look, I wrote, and let's just use a random number, I wrote 3% on the contract. MLS says 2.5%, but the title company got it from the buyer that's 3%. You don't catch it. Checks get cut. You get your commission check, and you're like, man, I'm shorted 0.5%. What happened?
It's on the contract.
Right. The answer that you're going to get, well, it's on the contract. Well, now it's too late. Now we have to go fight it. Now we got to go get attorneys involved and all that stuff to make it make any sense. Doesn't belong on a contract. Has no authority on the contract because, again, it's between a contract between a buyer and a seller. So the way it works, whatever is listed on MLS is what you get as a co-broke. Can you ask, are you willing to give me 3%, 5%, 70%? Absolutely. Nowhere does it say you can't ask for more or negotiate it or any of that. So you have that opportunity. Please do it up front.
They don't like that call.
Well, sometimes they also don't know what to say to that except, yeah, okay. Right? Like that's happened before. They're just, yeah, I guess.
There you go.
You just made yourself more money by asking a question,
Yeah.
right? Nothing against it. Now, you may on the flip side also get, no,
What's wrong with you?
right? Like you might get that, and that's okay. I mean, it was advertised. You knew what it was going to be. But please, please, please do not, and again, this is where I typically see it. People like to put it, just so you guys know, right here next to, I mean, they'll literally put like Wayne Bueller, 3%,
Oh,
and they have Jack Wagon, 3%. And I, in MLS, as the listing agent, am saying 2%. This is what they like to do. And then they send that contract, and then they say, oh, well, look, it's on the contract that you're going to give me 3%. This is the game that they play.
Make sure you check.
It's always good to, right? Again, you just want to make sure you get all that. Now, as well as all of this, always make sure, especially when we're doing this uneven split, that you tell the title company in an email, Section 21 JW Morton, 3.5%, Jack Wagon Real Estate, 2.5%. Again, it's in writing, it's in an email. That way, if for some reason the title company is working fast and they're like, oh, well, it's always 3 and 3, so I do 3. That's on the title company then. Now they're going to owe us money, right? So always want it in writing, and always make sure as the listing agent, you send it to the title company what the commission splits are.
So when you get this,
Mm-hmm.
do you just strike through it?
No, I turn around and call. I mean, I call the agent and say, hey, we don't put commissions on contract.
So take it off
Yeah.
and resend?
Correct.
Okay.
Yep. Now, I will gladly make that call for you if you don't want to make that call. I'll be the big bad wolf. I have no problem ever being the big bad wolf on that one. That one drives me nuts.
I have a question regarding commissions on on listings and
Yep.
showings. Flat fee.
Okay.
Can you explain that? Does that mean that they paid a flat fee and there's really nobody representing the seller?
Pretty much. Yeah, I mean, you're pretty spot on there. Now, as far as, what the fee is and how all that goes, I don't know because I've never been a part of, such a thing. But what I understand is seller pays $500 to Joe Schmo Flat Fee, flatfee.com, whatever it is, to get it into MLS. But they also still pay a co-broke percentage.
Oh, do they?
Yeah. So most flat, like when you see them on MLS, it still will have 1%, 2%, 3%. I mean, I don't know, I can't say the percentage. Some of them are, a lot of them are still 3. It's just all they're getting out of their seller, like at their listing representation, is MLS. because in the additional terms, it literally says, call seller directly at 352 blah, 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 blah,
Yeah.
to schedule an appointment, yada, yada, yada. And then it'll say, like, executed contract, please email to, so they have a copy of it. Now, couple of things I will tell you about that since we got on the flat fee bandwagon here. I have dealt with buyer, so I've represented a buyer where the seller was flat fee listed, and it ended up not going through. In my opinion, and I'm no lawyer, so don't call it law and fact, seller should have had the $5,000 escrow dead to rights. We were out of inspection period. We didn't have a finance. I mean, we were absolutely dead to rights as the buyer default. But guess how I wrote up a cancellation and release? With buyer getting, I wanted to try. Seller just signed it. They have nobody to tell them any other way, right? So again, if you've got somebody that's talking about, well, I'm thinking about flat fee or anything like that, there's one prime example where that seller should have been awarded $5,000. Yet they had nobody to ask. They didn't know. They didn't hire a professional to give them advice.
Would we get in trouble trying to solicit that as if they're not selling their house on time?
Correct.
Okay. So we would get trouble until expiration?
We're gonna get to it.
Okay.
You're jumping ahead, Joe.
All right.
But I like it. You're doing good.
Okay.
You're on
Trying
your
to make a
toes.
deal.
Yep. All right. Who fills out lead-based paint disclosure first?
So,
Seller.
Seller.
Woo! Seller does. Okay. So, a couple things that I see every once in a while from outside brokerages. House was built in 1972. Offer comes in, as is contract, $250,000. Also has a blank lead-based paint disclosure signed and initialed by the buyer with nothing filled out. Literally has no merit. It's not filled out. There is no point. It'd be literally like a buyer signing and initialing a blank seller's disclosure and say, here you go, I signed it. You signed what? A piece of paper that has no information on it. So, one, bad practice because it just doesn't look good. And also, maybe a buyer doesn't pay attention to what they're signing and whatnot, but I would not want to be that agent when that buyer turns around and asks, why am I signing a blank document? I'm like, oh, well, the seller hasn't filled it out. Well, shouldn't the seller fill it out first to let me know if there's lead-based paint in the house or they have knowledge of lead-based paint? So again, not a good train to go down. You're not going to look like a very educated agent going down that route. So seller fills it out. What do you do if you want to make, a buyer wants to make an offer on a 1972 home? You've asked the listing agent for the lead-based paint. It's not an MLS. What do? Do you make the offer? Do you not make the offer? What say you, Lindsay?
I'd make the offer and then request for the lead-based paint disclosure.
Tom?
I would do the same.
I'm not sure. And this is going to come in the form of a question.
Okay.
Can you, as the buyer's agent, can you go ahead and fill it out and send it back for the seller to sign?
No.
Okay.
You don't want to ever fill that out because you don't know it all. Because remember, a lead-based paint disclosure, there's a couple of questions that you ultimately have no knowledge of. Correct. So, on the lead-based paint, Section A, presence of lead-based paint or hazards. Known lead-based paint or lead-based paint hazard are present or seller has no knowledge. You're not going to be able to fill that out. And Section B, seller has provided the buyer with all available records, reports pertaining to it, or seller has no reports. Again, you don't know. You don't have them. So no, ultimately. Joe, what say you?
I'd like to get the contingency of getting that filled out.
Right.
I would
So
actually ask for it first,
Okay.
and then, hey, agent, I'm sending over an offer soon. Can I have the seller's disclosure and the lead paint disclosure? Sure, I'll send it right over.
Yeah.
If Sally doesn't send it right over,
Right.
I'm still gonna get the offer put together and sent.
Yep. So I like all of those answers. Those are all good. As an added security measure, you can also make it contingent upon receiving lead-based paint disclosure. The offer itself, in the additional terms, this offer is contingent upon receiving lead-based paint disclosure. Because, again, let's just say this agent goes on vacation, has no service after that contract's been. Now they've told you, Lindsay, yeah, we're going to get it to you. They've told you that, so you've relayed that to the buyer. Well, they're going on vacation and you got a 10-day inspection period, and the 10th day rolls around and you still don't have that addendum and you can't get a hold of them. Now what do? Right? So now you're in this predicament. If you wrote in the contract contingent upon receiving, you now have an out even after inspection period. Hey, we did not receive lead-based paint. So see, it just gives you a little bit. And I'm playing these scenarios out. This is not the norm. This is not the everyday thing, but I'm giving you the knowledge to basically give full protection to your customer. So you can 100% make a
And
contingent
by
on
getting
receiving
that,
that
it
document.
expedites the deal, so time kills all deals. You don't give that option for the time to get extended.
Right. Yep.
Wait, I'm sorry, I was out, but on this thing, whenever you have something like that, I've seen it, I really like the added verbiage of saying that, and if this is not received, this contract shall be null and void and all deposits returned
Right.
to the buyer.
And the additional terms?
Yeah, because.
So when you're writing, so contingent upon receiving lead-based paint disclosure, seller's disclosure, whatever form you are trying to get, you are unsuccessful in. Because again, I always first obviously want to ask the agent, hey, do you have the lead-based paint? Hey, do you have the seller's disclosure? I mean, that's step one, obviously, before I write this in the contract. And again, checking MLS to see if they have it. But also what Jim's saying, instead of just writing contingent upon receiving this, you add the verbiage of, if not
And
obtained.
in the event you do not obtain it, then this contract is null and void and it's canceled.
And escrow shall be refunded to buyer.
Are you attaching a timeline to that? By,
That is the timeline.
No timeline.
okay.
Yeah. You can, but again,
Usually an expediting a deal.
right.
Let me explain, this thing comes up again and again, and sometimes we get caught because let's say that the electric panel needs to be replaced or whatever condition of a home inspection, okay? And these are as-is contracts, so the seller really doesn't have to do anything, right?
Right.
But as an added contingency of the contract, because of the property inspection, the buyer is saying, well, I want this panel to be replaced, or I want this leak to be fixed, or whatever the issue is. And in that event, if it goes beyond the date necessary for the inspection, that inspection contingency falls out and you take the house as is. And if you say, no, I won't take the house as is, then you lose your deposit. And that's the critical part. Unless you declare that if this isn't done in this specified time, then the contract is null and void and the buyer shall be, receive his escrow deposit back. You see, because we've had people negotiate past the term of the due diligence and they haven't come to a conclusion. So contractually, that contingency drops out. If the seller or buyer says, no, I don't want it, unless you fix it, the buyer or the seller at that point can say, tough luck, you just lost your escrow deposit if you want to back out. And that's a really critical thing to understand.
Yeah, so to add to Jim's point, ultimately, at the end of the day, we've had scenarios where an agent writes, this contract's contingent on the sale of buyer's property, and left it that open-ended and that vague, not saying if it doesn't sell by closing date, buyer's escrow will be refunded back. So by leaving that gray area, you still, again, give somebody the thought, well, I can fight it because they did this, and this. But up front on the contract, if it says contingent on this, if this doesn't happen, buyer's money is refunded. They don't have any legs to stand on to try and fight that. It is clear cut. It makes signing that cancellation and release much easier. It's not a fight at that point because up front they were told, if this doesn't happen, buyer gets their escrow money back, period. On the flip side, escrow money to become non-refundable after inspection period. Can be used in all different senses, or after the 30th day, whatever the case may be. But again, if that's put on a contract, there is less opportunity for a buyer to try and find a gray area and arguing point to get their escrow. So whatever you're doing, and that's why I really love when you guys have a sale contingency, when the buyer has to sell their house, instead of writing in the additional terms contingent on the sale of buyer's property located at 123 Real Street, we have not sale of property. Yeah, here we go. Addendum V sale of buyer's property. And it was written by the Florida Association of Realtors. It says, this contract contingent on the sale and closing of buyer's property located at blah. Upon entering into a contract for the sale of buyer's property, buyer shall give seller a copy of such contract with third party's identification and purchase price information obliterated. If the sale of buyer's property does not close by blank date, buyer may, within 3 days thereafter, deliver written notice to seller terminating this contract, in which event the deposit shall be refunded to buyer, thereby releasing buyer and seller from all further obligations under this contract. Buyer fails to timely deliver said written notice to seller, this contingency shall have no further force or effect. So see, again, it's written out what happens specifically. Now I'll tell you, awesome job. Joan Donnelly had this filled out. And again, the seller wanted to fight with us on this. And we turned around and said, here's the document that you signed, clearly stating we're giving you notice, hasn't sold yet, we're getting our escrow money back. And that ended that conversation. There was nothing after that they could turn around and say, well, it's not defined clearly. It doesn't say. That's as clear as it can possibly be. So whenever you are writing anything in the additional terms, my thought is always, is there a pre-written addendum that covers what I'm trying to achieve? And I always want to try and go with that pre-written addendum first. Lawyers wrote them. They cover a lot of the things that pop up. So I always think about, is there an addendum for this first? If you're trying to remember what all addendums there are, the as-is contract does have a really good breakdown of most of them right here.
While you're there, will you go to the clause of forfeiture, or
In what?
in the event the contract doesn't close, what happens?
Well, it's,
Because this comes up over and over.
there's like 20 different spots because it depends on what, there's not like a blanket statement. There's like, so for instance, in the inspection period, it says during inspection period, you can cancel back out. It talks about having the ability of a walkthrough. So there's not like a blanket one-line sentence that says if the contract doesn't close, A gets their escrow money back, or buyer gets it back, or seller gets it back. There's multiple different parts in it. Is there like is there a specific?
Well, the reason I'm bringing it up is the contract says that if you do not close and it becomes contested, the escrow money, which is plenty times happening because no title company is going to release escrow unless they have both parties signing an escrow release that agrees to return the escrow to one or both parties, depending on whatever that settlement is. If you have to exercise the conditions in terms of this contract, there's something in there that says that the bailing party will get the money, and then the
Okay, yeah. So you're just talking about, okay, yeah, it is.
My point being, if somebody is upset and they're not going to return the escrow, even though it's obvious that they should, or even if it isn't obvious, you need to remind these people that whoever loses is obligated to pay both attorneys' fees, and that can run into several $1,000s. So as a matter of information to the buyers, you need to make them aware that this is a contract.
Yeah. So in any proceeding between buyer and seller where an agent is made a party because of acting as an agent hereunder, or in any proceeding where agent interpleads the subject matter of the escrow, agent shall recover reasonable attorney's fees and costs incurred to be paid pursuant to court order out of the escrowed funds or equivalent. Agent shall not be liable to any party or person for misdelivery of escrowed items unless such misdelivery is due to agent's willful breach of the contract. That survives closing, and there's also another section that talks about prevailing party.
Right. The important thing is when you go to court and you have to pay the loser has to pay both attorney's fees, it can run into many thousands and thousands of dollars. So
Here we go, right.
Go ahead.
Attorney's fees cost. The parties will split equally any mediation fee incurred and any mediation permitted by this contract, and each party will pay their own costs, expenses, and fees, including attorney's fees incurred in conducting the mediation. In any litigation permitted by this contract, the prevailing party shall be entitled to recover from the non-prevailing party costs and fees, including reasonable attorney's fees incurred in conducting the litigation. This paragraph 17 shall survive closing.
That's a very important thing to pass on to both buyer and seller, because it sometimes settles the matter before it has to go to court. And again, you can, $500 an hour is about what an attorney charges these days, so you can't get out of court for less than $10,000. And if you had to double that, you're spending $10,000 to $20,000 to get out, to gain and maybe a $5,000 or $2,500 escrow deposit. It just isn't worth it. But if you're not aware of that, you can put people in jeopardy.
And sometimes the buyer attorney doesn't mention that, and then the buyer is stuck. So there are some lawyers that aren't as professional as they should be by mentioning
Sure,
that.
absolutely.
So it's a great thing to remember, hey, this could be a problem if you're gonna have to pay both
Well,
sides.
this is
Yeah.
the consequences of,
Right.
of not being reasonable, and or if you have a question,
Sure.
is it practical in terms of enforcing a contract or return of escrow deposit? It's much more important to be practical than right.
So another huge point that I try and make is explaining the escrow process when an offer comes in. So again, first and foremost, that escrow money is a good faith deposit showing that the buyer is serious about buying. Secondly, this money gets used towards the purchase price. This is not additional. This is none of that. Next key that I try and make, the escrow money is held by a title company. We do not control who it goes to. We will fight for you. We will ask for you to get it when you feel that you are entitled to it, but we are not final judge or executioner on said topic. A buyer and a seller has to sign a cancellation and release to release any escrowed funds. Also, just on a note for you guys, the Florida Real Estate Commission, FREC, does not govern title companies. When you guys took your test and it talked about escrow disbursement orders and you have X amount of days to deliver and all of that governing stuff is when a broker like Jim Morton, Central 21 JW Morton, holds the escrow. If the broker holds the escrow, all of that stuff that you learned applies. In the real world, very few brokers hold escrow because of the liability sake. It's a lot more license on the line, FREC, getting angry at you stuff. So again, we prefer title companies. But again, I make sure that a seller understands that up front. Right? I don't want to explain it to them when they're pissed off because the contract is now, the buyer sending a cancellation and release to us a week before closing and they're still asking for it, right? I want to make sure they understand the process before the angry part happens.
Managing expectations.
Managing expectations, absolutely.
So I had an experience where I thought my very first contract that I did after I re-entered the real estate world was on my own property. I thought you had to wait for the contract to expire to do the cancellation release. As a result of that, there was a dispute over.
Who was that? Who defaulted?
Because you have to send
Right.
while the contract. So I waited till the day after it expired.
Right.
I just wanted to bring that up
Yeah,
in case
no.
somebody else doesn't know that.
Absolutely. It's a great point. Obviously, again, the cancellation and release is canceling a current valid contract. If you wait until the day after that closing date and whatnot, that's technically no longer a valid contract. And then could someone argue, well, you didn't sign the closing papers that were put in front of you. The buyer was ready, willing, and able to do it all. So that's a default on your part, not on the buyer. Buyer's going to get that's again what could have. I don't know how it all ended up,
I
but
was the buyer actually.
or so.
Yeah.
On the flip side,
Yeah.
you didn't sign the paperwork. Seller was ready to sell it to you.
Yeah.
So do you lose your escrow? And again, it's just gray area that now was made with that situation. So yeah, absolutely. You want to make sure cancellation and releases are done. Now, we'll flip back into the real world scenarios. We just recently had this with an agent where, seller felt very strongly that they were entitled to the escrow. And we had written up a cancellation and release reflecting that. buyer's agent was like, buyers ghosted me. Like, they don't answer my calls, they don't answer anything, so sorry, but there's nothing I can do. So this has put a blemish in the relationship between our agent and our customer here, because they're like, you know, I should get that escrow money. Well, we kept trying, you know, we're doing everything we can, but we also put the property back to active. And so, just so you guys understand, you can put a property back to active as there's an escrow dispute going on. There's nothing against that. However, a title company that is holding the escrow may say, we're not going to close this deal until this escrow is resolved, which in this scenario is what the title company told us. So we, again, consulted with the seller, and they said, let's go use a different title company to close this deal, which is all fine. There's nothing against that process. But again, there's still an open-ended question of what happens with this $5,000 escrow. So we get the property under contract. We actually close it. Seller gets their money, and you know, after they get hundreds of thousands of dollars, but you know what the question is at the closing table? I see you're getting your commission check. Why am I still not getting that $5,000? Is that fair, Mr. and Miss Agent? You're getting your money. Why am I not getting mine? So literally, we've done our job. We have sold the property for the amount that the seller wanted, yet they are still holding on to this escrow situation. So I am telling you all this because it happens. They are stuck on this escrow figure. Now, we went like Magnum PI, and we went through white pages. We reached out to the title company. We got addresses. When we finally found a phone number, I called the buyer directly after speaking to the buyer's agent, who said, you know, I got nothing. I left buyer a voicemail, and lo and behold, day later, she calls back and says, hey, I'm, you know, talking about my escrow money. Come to find out, well, she says, the lender told me I could get it back no matter what.
Oh,
And I said, unfortunately, ma'am, that's not great information to take on. You know, you really need to consult with your real estate agent on this kind of thing, and not just a lender. You want to make sure you read thoroughly through a contract. Again, I didn't say you're at default, you lose it, because again, I'm not the one that makes that call. What I did say, however, is we do have cancellation and release where the seller is demanding the $5,000 escrow. What say you? And of course, went back and forth, and finally I just asked her, are you willing to split it? Let me see what I can do, right? And so she said, yeah, let's see if we can do that. And ultimately, that's how we got everybody to sign. Seller got $2,500, buyer got their $2,500 back, and we ultimately moved on about our day. And hopefully we remedied some of the relationship that was blemished.
and
By
something
that
like that, it would be just the brokerage house. You would be doing that. We wouldn't be involved in that kind of negotiation.
Correct. Yeah, you can come to me on that every time. You gotta go.
Go to the chiropractor and everything like that.
All right.
My neck cracks.
So my understanding from the experience I went through is if it goes to mediation, generally speaking, they're going to split it. If there's not any real strong reason to go one way or another.
Right. Now, remember, mediation is buyer.
I meant arbitration.
Oh, okay. Yeah, I was gonna say, but you got to try and mediate first,
Okay.
right? So, buyer sitting on this side of the table, seller sitting on this side of the table, and a mediator is in the room. The buyer and the seller still have to come to an agreement in mediation, right? So, like, that's mediation. It's still in a room between buyer and seller. If that doesn't satisfy it, and we go to litigation, arbitration, any of those, then it's a judge deciding you're getting it, we're splitting it, whatever, but it's an outside party that ultimately is taking the facts and the story and saying, here is who gets it.
I like the line that Jim said about it's much better to be practical than right.
Right.
And giving that to the expectations of what might happen. It's,
Yep.
I know you feel you're right, but it's being practical is really going to get this done.
My critique of the story that I told you with the agent, where our agent, I think, could have done better, is explaining the process at the beginning, before everybody's pissed off.
Yeah.
Right?
Expectations.
That's where you explain the situation so they understand the process before emotions are high. Again, They were getting hundreds of thousands of dollars, yet they were stuck on a $5,000 escrow deposit from a previous deal. That's sometimes the way the cookie crumbles. Who submits an executed contract to the title company?
I always do it.
Seller's agent.
It should be the seller's agent, but if they're not doing it, I agree with Tom.
I always do it.
I like Tom's answer.
Yeah.
So my answer to it is both parties, all parties, whoever you're representing, do it. So this is kind of one of those weird things. The way that I was taught is it's the buyer's agent. Why? Because they're the ones that are dealing with the escrow check, right? So the executed contract has either an escrow check accompanying it or to be made within 3 days. That's on the buyer's side, so buyer's agent. Now, I have personally been burned that way in the sense of it was vacant land. I assumed that the buyer was sending it. Well, lo and behold, I didn't do a good job of making sure escrow was in. So we get a week before closing date, and the guy's like, "Can I get an update?" And I email the title company, and they're like, "We never got a contract." Not a good position to be in. So no matter what, you send it to the title company. I don't care whether you're the listing agent or the buyer's agent. Send it to the title company. Period. So Tom's answer is the best answer.
Okay.
All right.
Yay.
Yes.
Can an inspection period end on a weekend?
Yes.
Yeah.
Yes.
Are we sure?
It's the date that's in the contract.
I would never put it on there.
Yeah.
Like,
So, what days are used on a contract? Calendar or business?
for the inspection period, it's business days.
Are you sure?
Well, that's what I'm saying. It's not. So it can't end on a weekend.
It cannot end on a weekend, or it can end on a
It
weekend.
can't
Okay.
because it's not. The inspection period is not business days. Escrow is. But inspection period, I don't think is weekdays or business days.
So, first thing I want to show you is this part. Really need to memorize where this one is. Time, section F, line 432, page 8. Time is of the essence in this contract. Calendar days, based on where the property is located, shall be used in computing time periods other than time for acceptance and effective date as set forth in paragraph 3. Any time periods provided for or dates specified in this contract, whether pre-printed, handwritten, typewritten, or inserted herein, which shall end or occur on a Saturday, Sunday, national legal public holiday, as defined in section 5, or a day in which a national legal public holiday is observed because it fell on a Saturday or Sunday, shall extend to the next calendar day. So, can an inspection period end on a weekend?
No.
No, it cannot. These questions are written this way because I want them to be kind of trick questions for this reason. Calendar days are used in a contract, and it states if it ends on a weekend, it goes to the next, except for time for acceptance and effective date. That one is business days, so it cannot end on a weekend, period, because you're using business days. But anything else, you get that. So there are certain agents that use that to their advantage, and they put 10 days as an inspection period. Yet if you play it out, well, the 10th day is a Saturday, so really I get to Monday, I get these 3 days. I don't like playing that game, but I want you guys to understand the contract so you can know, and again, use that timeline sheet to see exactly when does an inspection period end. Because here's the kicker. You tell the seller, hey, it's 10 days, it ends on Saturday. What idea does a seller get in their head on Sunday or Monday when the buyer wants to back out? I get the escrow, the inspection period's done, right? And then you come to me and you say, Wayne, here's the situation. I have to tell you, well, hey, here's in the contract where it says if it lands on a holiday, it goes to the next day. So now you got to turn around and go to your customer and say, I was wrong, my bad. I didn't know the contract, and not a great scenario again. So You guys now know inspection period cannot end on a weekend.
So if it ends on a Saturday, it ends on a Monday.
Correct. Unless Monday's a national legal holiday, then it'd actually be Tuesday. But yes, that is correct. An inspection period cannot end on a weekend. Good?
So, I mean, this is almost deceptive, but if you have like a 14-day inspection period, but the 10th day falls on a Saturday, or
The
like,
14th day falls on a Saturday.
well, let's say the 10th day would fall on a Saturday.
Right.
Wouldn't you just write 10? And then if you have like those 3 holidays, so just
If you,
to make it look better.
correct.
but-
Yes. Yes. And that's where I'm saying, like, I don't play that game. I don't try and use it to my advantage to look that way, because at the end of the day, it's just hurting the relationship between you and the other agent, which, guys, agents can make or break deals. As much as we hate to say that, they can. So I try and stay on an agent's good graces, not bad graces. Yes, sir.
On the effective date
Correct.
that we put in there,
Mhm.
you said it has to be a business day? Can it be on a Saturday or a Sunday?
So right here, it says business days. So we're using calendar days based on where property is located, shall be used computing time other than time for acceptance and effective date, because here it does say,
It's not like a 3 days thing, it's a day.
correct. It says time for acceptance if not shall be on or before this offer shall be withdrawn, deposit shall be returned by or unless otherwise stated. Time for acceptance for any counter offer shall be within 2 days. The effective date of this contract shall be the date when the last one buyer signed or initialed and delivered, and then the closing of this transaction shall occur. So again, what they're saying is, like, closing can't happen on a weekend,
No,
so
I
we're
understand.
not using it.
I'm talking about the effective date that we put in there. I thought you said that has to be a business day, but it could be a Sunday. We could say that we want.
Oh, if I said effective date, I meant time for acceptance and closing date. I thought, yeah, if I said effective date can be whatever day is
And
signed
that
and
date that
delivered.
we put in there can be a Saturday or Sunday. If we say we want an answer by Saturday or Sunday, we can put that in and that's the date. It doesn't change, right?
That one I would strongly tell you not to do because of section F under time, where it does say, and again, we're creating a little bit of gray area here, but again, it says calendar days based on where property is located shall be used other than time for acceptance and
That's the
effective
date
date.
I'm talking about.
Right,
So
so,
that can be on a Saturday or a Sunday.
well, if you're using calendar days, it can be a Saturday or Sunday, but calendar, they're saying other than time for acceptance and effective date. So we're getting kind of a gray area.
If I give an offer to you
Mhm.
and I give it to you, or I'm accepting, or I'm gonna put you an offer in and I give it to you on Friday, but I
Right.
want an answer back on Saturday or Sunday. I don't want to give you all the way till Monday.
Right.
So I can put that in there. I can put it, we can do.
Correct. Yeah, you can put that in. I'm just saying, could somebody argue it using that clause? Possible.
It says other than time for acceptance.
Correct, meaning that calendar days are gonna be used in everything other than time for acceptance, and because it's a set date.
Do we have, who's on the phone, just out of
I
curiosity?
think we got like 9 people.
Okay, let me say something. A lot of newer agents think that half-truths are something very clever in terms of how they exercise the disposal of a contract. And that's the worst thing in the world, is to not know this stuff. You got to know what the effective date is. You have to know time acceptance. You have to know that holidays don't count in terms of your inspections. The other thing that we ran into recently is, in Wayne, aren't we supposed to get a receipt on an escrow deposit?
Yeah, it's one of
We
the,
have an escrow deposit and the agent neglected, and it turns out that the people never put up the deposit. So then it becomes a question of, well, the seller wants the deposit. Whose responsibility is it to have the seller get that $5,000 deposit? We were negligent in not getting a receipt of escrow deposit or following through on it. The title company apparently never let us know that there wasn't. So what happens then? The seller's wanting $5,000, and where does it come from? That's a test question.
well, I'm gonna disagree with your answer, but to whatever, if it has to go to an attorney, it's gonna be what the judge tells us. It doesn't instantly put it on the agent, but you're going to say that it instantly puts it
No,
on the agent.
it isn't, because we discussed it. I thought our company was responsible to give them the escrow deposit. Turns out it wasn't our responsibility, but you can see how that would destroy a relationship.
And also in a court of law, they may decide agent was negligent, and yes, you are responsible. So like, it doesn't completely alleviate us.
I just
From
don't
that
want to
responsibility.
if you discharge your responsibilities as an agent, and don't think just because you're an agent, you don't have responsibilities. You're held to a much higher standard, and you're expected to know these things. And quite frankly, it doesn't really fall on your shoulders, it falls on my shoulders. So I'm responsible for your actions, you're responsible to me, and that's why I'm saying to you, know your contract, get a receipt, an escrow deposit. Don't let it be overlooked. That's totally inexcusable to not receive an escrow deposit. And why? If you don't have an escrow deposit, what does it mean?
Not valid.
Why?
You don't have consideration.
You don't have consideration. So you see, you never had a contract to begin with. But we've been moving along under the assumption that we had a valid contract, and because of our negligence, we didn't have a valid contract. And I'd hate to go to court in front of a judge and say, it isn't our fault, when it is your fault. That's why I would just as soon write a check for $5,000 and go to court and have to defend that because it cost me another $5,000. The only exception to that is we have errors and omissions. But is negligence an error and omissions is covered by error and omissions? Can you answer that question?
I don't think negligence is something, but I don't want to give you a 100% definitive answer.
If you do something fraudulently, we're not covered. If you do something in error, that possibly is covered.
Right.
But again, you're in a gray area, and by the time you discharge that in court, you spent more money than it cost. And I learned this a long time ago. I was righteously indignant, and we deserved justification by the courts. And my insurance company said, the heck with justifications, we're going to get out of here as cheaply as we can. And they ended up writing a check.
Settling, right, settling. Again, insurance company is always going to settle.
Dispute because time is money.
Right.
So we just simply have to know what's in the contract, and we have to discharge our responsibilities accordingly, okay?
Yeah.
So make sure you get an escrow deposit. That's a sacred, sacred cow. Escrow deposits. And of course, the effective dates of the escrow deposits.
Does a buyer get an automatic extension of inspection period if a repair addendum has been submitted? Brittany?
No.
Tom?
No.
Good job.
Absolutely not. That's
Right.
exactly what we're
Correct.
talking about.
So, no, it doesn't give an automatic extension. And here's the real life scenario that happened. Inspection period ended. A repair request was submitted. Then the buyer backs out, wants all of their escrow back. Seller says, well, no. Buyer's case is, well, we sent you a repair addendum, right? So that's the scenario at play. Everybody understand the scenario at play? What is a seller's, or even a buyer's, but typically a seller's answer to any kind of addendum or negotiation? Yes, no, or no answer. The Florida Real Estate Commission, no answer is a legal answer, right? You as a buyer's agent have, again, a higher duty to, on the 15th day or 10th day or whenever that inspection period ends, to say, Mr. and Mrs. Buyer, the inspection period ends today. I have not received an answer on your repair request, negotiation, price reduction, whatever it is. Would you like to continue moving forward knowing that you lose the protection of the inspection period, or would you like to go ahead and sign a cancellation and release right now, protecting your escrow money so I can submit that on the last day of the inspection period to protect you? That didn't happen in our scenario, and one of our agents had to pay up some money, and also we had to pay up some money. Again, it would have probably had to go to court to settle it out, which is, again, the worst option for all. We also had an upset seller, an upset buyer, and we had both sides of the deal with two different agents in this office. We're talking about multiple relationship killers. So please, please, please make sure you're not required, like Jim was saying, you're not required to write a $5,000 escrow check if your buyer doesn't submit it. However, what you are required to do is say, Mr. and Mrs. Buyer, you have 3 days from today to get your escrow money to the title company. You can write a check made out to First International Title and I will deliver it to them. You can mail it to them. You can wire them. I will have them call you with wiring instructions. But it is your job to let them know the time frame that they have to submit it. You need to, and you really want to make sure you do that in some form of writing. If it does come back, just again, as a CYA, you can say, look, here's the email that I wrote to buyer@gmail.com that says, today is the effective date. Here's your executed contract. You have 3 days to do it. And again, you should be writing them an email when you have an executed contract because you want to give them a copy of it.
Wayne, it goes beyond that too, though, because if you don't get it, it's your obligation to get it, but if you can't get it because they haven't put it up, you need to notify the seller. So what does that mean? We don't have consideration, so we don't have a valid contract. It ends right there.
Right.
Now, you can sue for that, by the way, but that's another story entirely.
Yeah. And also, again, the whole idea of why I'm having this class and whatnot is not to hide behind like, well, buyer, you got to go sue them, or seller, you got to go. That ends relationships. When your answer is, I can't do anything, sorry, go find an attorney. A seller or buyer usually aren't, yeah, great advice, Joe, I'm going to go do that, right? They're not excited about that answer in any way, shape, or form. So again, I'm educating you guys on the processes, so that is not the answer you have to give somebody.
One more other comment. When you have signed an as-is contract, that is a meeting of the minds and it is a contract. Further negotiations is not a meeting of the minds, and that's why if you don't get an answer, you need to submit the cancellation of the contract along with the request from the buyer has to submit that, put it in writing, and submit it to the seller. And if it isn't accepted, then it automatically is canceled. That gets back to what we were talking about earlier.
So like a practice that I've seen is when you submit a repair request during the inspection period, you also, and again, you have to ask the buyer if this is the stance they want to take, but you also submit a cancellation and release and basically says, here's the addendum, sign this if you agree to repair, here's the cancellation and release, sign this if you don't agree to do the repairs, and buyer gets their money back. Like you are laying out the options. It's take this or take this, but I presented both to you, so we cannot argue that you were not given.
You need to present
those
that
options
in one form though, because it's either repair or cancellation of contract, the buyer signs it, and now the seller, if he signs it, he agrees to do the repair. If he doesn't sign it, then the contract automatically cancels.
So if somebody sues, it's for lack of performance, correct?
Not necessarily.
There's all different kinds of, depending on what the situation, all that specific performance, breach of contract. I mean, again, we're getting into attorney, but there's all different kinds. But yeah, Jim's absolutely right. You can do it. Now, here's the part that is going to add to that. The title company may or may not accept that repair addendum as the quote unquote cancellation and release. They may still want the actual form that says buyer gets $2,000. So you may still have that form. But again, putting it all on one lays out, seller, here are your options. What say you concept? When should lead-based paint disclosure be fully executed? Brittany.
At the time you're doing the contract?
Tom. This is a preferably question, I guess.
Well, preferably,
Yeah.
with the offer.
Yeah.
I agree.
And we kind of already talked about it, but yes, preferably obviously with the contract. Again, we talked about kind of a contingency as writing in the contract contingent upon lead-based paint disclosure provided by seller if you don't get it. So I'm not going to spend too much time on that since we already did. Where's the energy brochure located?
So like for us or just in general?
Just in the world of real estate.
Part of the contract, isn't it?
Well, I'm going to get to it, but you're on the right track.
I forget.
I don't know either.
So have to do something with the HOA.
Nothing to do with the HOA. So, first things first, Jim answered on the contract. Well, that's partially correct. So there is mention of an energy brochure on the contract, yes. And what it says is that an energy brochure has been provided, right? So my question is, where does one find said energy brochure?
I can't think of the name right. It's like the fair housing something.
Where are you? I don't want to take too much time finding it, but I know it's somewhere. Yeah. So the correct answer is in app files.
Where is it?
In app files.
Yeah, files, yeah.
So literally, if you go, I'm just hitting print blank forms, but in your app files, if you say add a form and you type in energy, there's the energy efficiency brochure. So
The important thing though is the disclosure in the contract saying that.
correct, that the buyer has received this. The reason I bring this up, I just had an agent come to me and they received this offer and they're like, Wayne, I got the offer, and they represent the seller, but it's like, but in the offer, there's like 10 pages of stuff that I have no idea what it is. So I look at it and I was like, oh, that's the energy brochure. And this is how they're basically covering their self saying, look, it's going attached with the offer. But in our contract, it does say that a buyer has received this. So this is, again, you should, in a perfect world, Walgreens commercial, be sending this. And I want you guys to be sending this because the contract says it. That's it. Just email it to them. Get used to it. I mean, we can add this to the checklist if you wanted, but this is something that the contract does say buyer has received and reviewed.
Hey, Wayne,
Obviously. Yep.
could we just merge it with the standard contract so it's always there?
We need to find it because I'd like to see it. It just makes you aware of it, or you have to actually submit.
Yeah, I'll look, Judy.
We can add it to the buyer paperwork.
Right, and so the reason why I don't know if I would completely fully merge it is because if we're writing up a counter offer for a seller, that obviously is then not part of our duties, roles to do. But I'll look exactly what it says in the contract and we'll come up with a plan of making sure. And again, one thing will be when an offer goes pending to shoot a task to you guys on the buyer side that says, has the energy brochure been emailed as well?
On the checklist, we could just add,
Email energy brochure or something like that.
well, yeah, or like in your, you have to submit the energy brochures.
Right. But yep, we'll make that work.
Thank you.
How should, go ahead, Judy.
All set, thanks. I'm all set, thank you.
How should you write a financing closing day extension? I'm trying to give you guys hints in this one.
An extension addendum.
Very carefully.
I mean, all great answers, but I am asking specifically, how would you write it? Brittany, if I was extending a closing date and I have financing involved, what does that addendum say?
Buyer and seller agree to extend closing.
To X day.
Yes.
Okay. Final answer?
I would have some.
You need to disclose the financing too.
Yeah.
So that's the part that I want you guys to remember. You're not just extending the closing date, you're extending the loan approval period. If you're writing this addendum, you're representing the buyer. If you're writing the extension of a closing date, please also extend loan approval period. Buyers always assume that if we're extending closing date, it's protecting them because typically we're extending it because a lender needs X document, Y procedure, hasn't got what, appraisal hasn't happened yet, survey hasn't, all of the above, right? But if you just write extend closing date, well, in our contract, the closing date is obviously separate because the closing date is here from the financing contingency. Two separate parts of the contract. Extending the closing date does not automatically grant an extension of the loan approval period. Clear on that? Make sense?
Yeah.
Good?
Mhm.
Okay. What is an escalation clause? Brittany? All right. Tom?
It is a clause where, especially if you have multiple offers, that you basically say, I'm willing to go up in my offer at this increment, so like $1,000 up to this exact price. So
I agree.
Tom got it right.
Ditto.
Okay. That is correct. So I did a quick end, but it's a way for a bid up for a buyer without having to go all in at the beginning. So, and I'll pull it up real quick. We're going to talk about it. They become less apparent because obviously multiple offer situation is not as prevalent as it once was, but there are enough new agents that I wanted to make sure I covered the bases. So obviously you put seller, buyer, and the property here. You put the original offer amount here, or whatever the contract offer amount is. And then you put what the contract is, and then here you complete, the buyer completes this section. Buyer agrees that purchase price shall be increased by, again, whatever the increment is, in this case it's $500, over the purchase price set forth in competing offer up to max bid of $159,500. So the reason that I bring this up is because I just had an agent with multiple offer situations, and they were representing, they had the listing, and they were representing 2 out of the 4 offers that came in. This is, guys, you want to be real careful because what kind of brokerage relationship are we practicing here? What are we presumed to be? Transaction brokers. And what does that mean? We can represent both sides, right? We do not have full loyalty and full disclosure to one side. We can't detriment one side to the other. So this agent couldn't say, hey, buyer number 1, buyer 2 just wrote a contract for $140. You need to be higher than that and not also, with the seller's permission, disclose that information to all parties. So kind of a sticky situation. So I told him, why don't you, 1, go back with highest and best across everybody. That would be what I would recommend to the seller. But also, you can recommend to your buyers, hey, we can use an escalation addendum or an escalation clause. So you can say, I'm willing to go up to this number, but it's only incrementally. So I can say, I'm willing to pay $200,000 for it. But if I can get away with paying $182,500, that would be obviously much better.
What's the typical date of that process? What's the end date of that escalation?
Well, this you want to submit with the offer, or if again it comes in as highest and best, submit the offer and then add this in as your highest and best.
Okay.
Talk about a reasonable acceptance though, right, of counter offers.
Right.
That's an ongoing process. It should be handled within a 24-hour period.
Okay, thank you.
So what I don't want you to do, which I will tell you I've seen by agents outside of this brokerage, you don't know if there are multiple offers, and your one and only offer submits this document telling me, the listing agent, that your buyer's willing to pay $159,500 for. You don't know if there's other offers. So guess what my suggestion to the seller is as far as a counter? Let's counter at $159,500 without an escalation clause, because we just found out they're willing to pay that much for it, right?
Yeah.
Don't be the agent that submits an escalation clause right out of the gate because you're trying to win it when you don't know there are multiple offers. So ask the question, are there other offers on the table? Because the other thing you got to remember, a seller doesn't have to come back with highest and best in all parties. They could take it, the first offer right out of the gate if they wanted to. So you want to ask the question, are there other offers? So now I know, do I want to broach this subject with the buyer because yes, we have other offers on the table, or we feel comfortable enough with our offer to move forward without something like this. But you don't always get the highest and best opportunity. So don't ever assume that you're going to get a shot at it again when there are multiple offers. That will turn around and bite you as well, because that's not always the case. I've literally had sellers say, I don't want to deal with all this stuff. This cash deal at list price is all I care about. I say, are you sure we could get you more money? Yeah, I'm sure. Okay.
Wait, a couple of things on that. It's always good business to offer on multiple offers, last and best. We had one where the seller just outright accepted one of the offers and the other people involved submitting contracts said, well, why didn't we get last look at it? I have to agree with that to a point, unless the seller's adamant about, I just want this offer, I like this person, you had lesser offers because the people like the people. But that's very important that you get last and best so that you are in fact representing your seller properly. Secondly, if you do have an escalation clause, let's say it went from 150 and the next best offer was 155. That doesn't mean that you can pay 159.5. You have to prove to the person that that was the highest offer and you cannot exceed that or you're in trouble. And finally, I would like, if there's this situation arises, I would like management to be involved. If it's a party where you're representing the seller and the buyer, and we will take one or the other side and represent that so we have separation of interests, okay?
Yeah.
Just let us know, just do what's fair and do what's honest and get us involved with that, because that can be really tricky.
And of course, we'll take that commission. No, I'm just kidding.
It's a courtesy to
Right.
the.
So we saw the section completed by buyer, and again, I'm just relaying what Jim just said. It says seller to complete this section. Seller agrees to the revised purchase price calculated as competing offer purchase price plus escalation amount not to exceed maximum purchase price of 158. So in this scenario, the offer that came in was 158,000. The escalation bumped it up to 158.5. However, it does say seller shall provide a copy of the competing offer with competing buyer's identification redacted at or prior to time seller accepts or counters buyer offer in writing. So again, to prove Jim's point, you can't just say, yeah, I got another offer for 158, so you have to go to 158. It literally says you have to prove it to me with a physical contract of that price. Yes, you can strike through the buyer's name. I don't need to see the buyer's name, but I need to see a contract document signed by the buyer showing that situation.
Now, if you have knowledge that the seller's willing to pay 158.5, and
You
you
mean
have
the
both
buyer.
sides of this,
The buyers.
the buyer, and you have both sides of the sale, where are you obligation, or what are your obligations? Do you tell the seller he'll pay 158.5 and do what you said earlier, just go to 158.5 on a counter, or do you have to protect your fiduciary relationship with the buyer as well?
I don't think you would tell the seller 158.
Your obligation is to get as much money as you possibly can, right? And you know the seller's gonna, or the buyer's gonna pay 158.5. So what is your proper position in that? That's a question.
I think to
Well,
disclose,
Lindsay gave her answer. You guys have yours?
I think to disclose to both parties the knowledge that you have and let them decide. That's a good answer.
I think you talk to management and let management have one side, you handle the other, and then it's a separation of
Right.
interest so that you're not going to compromise one or the other. Because I can tell you have a fiduciary with the buyer as well as the seller. Got it?
Yeah, that's my answer again, is you are representing both sides, so you don't want to do something that detriments one side to the other. And again, are we detrimenting one side by telling the seller they're willing to go up to 158.5? Kind of. There can be an argument made that says, well, my offer was 150 and you were the one that told him after I told you in confidence that I was willing to go up to 158.5. So absolutely, again, that's where that separation.
Even though it's written on the contract?
No, we're saying this was not filled out.
Oh, gotcha.
We're saying
That's great.
you're my buyer and you
Okay.
tell me, hey, let's write up 150, but I'm willing to go up to
Okay.
158.5. And you're also the listing agent. So now you turn
Right.
around and tell, hey, seller, they're willing to go up to
I'm
158.5.
gonna call it right
Go ahead and
now.
discount rate then next. Not, again, detrimenting you for the benefit of you.
I got you.
So you want to be careful. And also, one thing too, when like FREC gets involved, if there was like a buyer brought up a complaint and whatnot, FREC also looks into the agent's interest. So by raising the price, what also happens? The commission goes up, right?
Correct.
Then that argument can also then be used. Are you benefiting yourself, which FREC hates? If they get something that says you're trying to benefit yourself as an agent over the clients, they really get angry. So again,
With an escalation clause,
Yeah.
they already know it.
correct, with the escalation clause, and that's why I'm telling you, if you don't know there's multiple offers, don't jump the gun and use one of these, because then you are saying, hey, we're willing to pay this. When is a contract enforceable?
Everybody signed it?
And
With consideration.
Tom, when is the contract enforceable?
When both parties are the parameters of the contract.
Both parties have signed and it's been delivered.
that's what I was,
We're all right in a roundabout way, but what the answer I mean, when it's in writing, okay?
the assumption is that.
Get it in writing, right? This is 101. You guys were thinking too far into specifics of everything. All I'm saying is get it in writing. When you have a negotiation going on, you know what words never leave my mouth? We accept. Let me get it in, let me get the seller to sign it, right? One, what happens if you say that and then another offer comes in 2 minutes later? What is your legal obligation to a seller with any and all offers? Present them, right? So then the next conversation that the seller's probably going to have is, well, do I have to take offer number one? And what is your answer?
No.
It's not in writing. Who looks like a jackwagon? I don't ever say, we accept, I'll get it signed. The second that I tell a buyer's agent we accept is in the email with the signed paper, whatever it is, addendum, repair request.
So much.
What?
That, hey, the seller accepted, I'll have that contract over to you once.
All the time.
Yeah.
It happens all the time. I don't do it. I have seen so many agents get burned.
Stop doing
I have seen so many agents get burned.
So is it just, because everyone likes to do everything orally before they put it in writing.
Right.
So the back and forth is not in writing.
Right. The negotiations can be verbally. I'm not saying you don't do. Now, I personally think it's better to do them in writing
I was just gonna ask.
because,
you.
again, for me, I'm trying to quote unquote lock this deal up. So if I'm verbally going back and forth, we're going back more than that, then I'm trying to get us a signed contract. So I do it in writing. And I mean, there are a few instances where it'll be a quick text or something like that if there's something we need to change. But for the most part, my negotiations are in writing.
Okay.
That's just a habit that I've made for myself. And I think it's better that way. But again, what I will never do is once we have the meeting of the minds is tell the customer, tell the agent on the other side, whatever, we accept without having it signed.
Gotcha.
Just not, and again, if I receive that message, I also say, please get it in writing, or do you want me to write it up? Again, depending on the scenarios, if it was the last verbal on my part, it's going to be, to me, my duty to get it in writing. If it's the last part on them, a lot of times I still offer to do it because, again, I'm trying to get it locked up. So we know a situation that you had with another agent of like getting an addendum. Yeah, I'll get to it. Well, 3 days later, we finally get to it, right? Like the weekend had passed. I try to not do that because, again, your customer's sitting there waiting a lot of times too. Like, hey, what's going on? And your answer is, well, I haven't gotten anything yet. It's not a great answer. So if you have to step up and write an addendum or write the contract with the new terms, again, I don't have a problem doing that. A lot of times I feel more comfortable doing it because, again, I'm the one that's writing it. Now, one thing to say about that's happened in the past. The original contract had, for instance, a home warranty on it. That part wasn't negotiated. It was the price that got negotiated back and forth. And then when the final offer was written, that home warranty was now gone. And buyer's agent was the one that typed it up at the end. And then the buyer's like, well, where's my home warranty? Now buyer's agent's like, oh shoot, I didn't catch that. What are you gonna say? Too bad, so sad. What's writing is important. You should have read your own contract. Again, all horrible answers. So you're probably gonna say, well, it looks like I'm paying for a home warranty for this one, right? Right. So make sure you read through the entire contract when you're negotiating back and forth so you understand what all is there. Another huge one that happens all the time, not all the time, but that I've seen quite regularly, is instead of using the additional terms on like seller to pay closing costs or something, They put it right here in the, I mean, it says cost to be paid by seller, and they'll write closing costs up to 4%. And our agent just gets it, boom, 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 boom. Yeah, it's great. Here's an offer for $150,000, pretty straight up. You like it? Sure. All right, I'll send you the signature request. And that was not caught. Who's going to pay that 4%? Now, again, you have a conversation, and you can say, well, you should have read your contract. You're never going to have business. And again, if you continuously do that, you will be kicked out of this industry. You won't have any referral business. So again, please thoroughly go through the contract when you receive an offer so you know what's on it. I know,
I was gonna say,
obviously,
you're free to use my
Yep, yep.
example.
We'll talk about it. Katie's scenario was a very interesting one, and just to breeze through it, there was a lot involved, but ultimately seller requested, so seller owned, let's just, an attached townhouse. There's 2 units, basically like a duplex. She lived in one, inherited the other, and wanted to sell this other one. Her request was, I don't want an investor purchasing this property. All right, is an investor a protected class?
Yeah.
It is not a protected class. So that is fully legal, we checked, for a seller to say. That is okay. Again, it's not race, religion, any of that, skin color, not any of that stuff. So we're good, not a protected class. Offer comes in with so-and-so LLC. It was asked if this was going to be an investment property. The answer was yes, so that offer was denied for said reason. A week goes by, same agent makes a new offer with a different name. On the contract, the assignability section was checked. So the same question was asked, not a very clear, concise answer was given, or actually even provided at all initially, whether or not they were going to be
He said
an
he was
investor.
out of state owner.
Yeah, out of state owner.
A couple months out of the year.
Right. So again, a gray area question, they're going to be there a couple of months out of the year, but what are they doing with the other 10 months out of the year? So vague.
It's a half-truth is what it is.
Right. Playing that half-truth game. Well, full scenario is the seller is also the HOA president, so she has to obviously approve the person coming in. Well, on their questionnaire, it says, are you going to rent out property? Are you going to use it as a, whatever. That was checked, yes.
Well, it also came back with the original.
No, the name on the application for the HOA was the original offer's name. So now we call up the agent, and the agent basically says, well, under this contract, it was checked, may assign, but they're not be released on liability. So just so you guys understand the assignability part, when that's checked, the buyer has the ability to assign someone else to it without having the seller sign a document. I mean, that is what assignability means. They can assign it to someone. They can change the name on the contract for their party. Now, when this one's checked, it says they cannot be released from liability, meaning they're still held liable. But again, the person buying it, the name going on the deed can be changed, can be assigned without a seller having to sign something, even know about it. Now, again, horrible business practice here, very deceitful tactic. And that's, again, lots of things went south, and ultimately an attorney even found a way out of this. So this deal crashed and burned ultimately for the good, because again, our customer did not want. We did not do that now. We also had very interesting answers on that one. But again, full circle, Katie beat up herself a little bit because she did not catch this part when that offer was originally sent over, because again, hindsight's 20/20. We can obviously say, yeah, that totally would have been a red. We're not sure that would have been a red flag, but it potentially could have raised a question. Hey, why do you want to assign this contract? Right? So again, make sure you do read between all the lines, check to see what boxes are checked. Again, I teach you guys, this is my default. The safe, very black and white one may not assign, but when I'm representing a buyer, I ask the question of, do you want to assign this contract? Oh, what does that mean? Well, what we typically see is like you want to put it in an LLC or something like that. Now, if I was, let's just say I was representing that buyer, there is no way I would have went on with all of that because again, that half-truth, deceitful, ethical violation, I mean, there are a lot of things that could have got this agent in trouble and still get him in trouble for practicing real estate that way.
You want to check the second one though, maybe assigned but not released to the
No.
seller.
Oh, yeah, well, I mean, the seller's typically not right. We're not typically writing a contract for a seller, so it's going to come in from a buyer's agent with an offer.
My point is, we don't want to accept a contract, it can be assigned and dumped because of.
Right, so this one you typically, oh, I'm sorry, this is my default one, may not assign.
Right.
That's my default one. Yeah, I'm sorry. I had them out of order. Sorry. May not assign is my default option. If we're going to assign, it's only going to be, I don't think I've ever seen, nor would I want that first one. Because again, it completely alleviates liability from the person that originally signed this contract. Clear on that? We're almost done. Who is at fault if buyer never receives seller disclosure?
The buyer's agent. Seller's agent, both.
I mean, yes, but for the sake of this one, I'm saying buyer's agent. So again, this here is so important because one, if things go south and we have to go to our errors and omissions, they require certain things to happen. Obviously, they're going to need the executed contract. They're going to ask, have inspections been done? And again, if they haven't been done, we want to make sure we use the J.W. Morton broker addendum going over, hey, I decline all of these inspections, so they don't come back and say, well, Joe didn't tell me I could get a termite inspection. He may have talked about a regular home inspection, but he never told me that a termite inspection was a real thing. So yeah, we're creating gray area. You want to make sure that's signed. But number 3 is seller's disclosure. Right? Was it done? Now, by law, does a seller have to fill out the actual form that says seller's disclosure? By law, the answer is no. Our office requires it. So we're going to tell you, by our law, yes, you have to have it. If they have never lived in the house, we have a form that says seller's never occupied home. We require that form. Okay? So we're always going to have some kind of seller's disclosure. Now, if you cannot get one from the other party, when you represent the buyer and the listing agent can't provide and whatnot, you make sure you have in multiple emails, texts, in writing that a seller's disclosure was not provided from seller, brokerage, whatever. You want to, again, have that, and then we want to relay before closing to buyer, we have not received a seller's disclosure. Are you okay moving forward? And you probably want to do that in writing as well.
Frank, can I make a comment?
Absolutely.
If we have a situation where it's a third party, like it's a property inherited or someone's died and there's a trust or something to that effect, and the seller does not know, we still need it unknown and signed by whoever the person representing the seller is. That's perfectly valid because they don't know. They haven't lived there. But we still need it signed and said we don't know. That puts the buyer on notice that they need to take very particular attention to what inspection.
Jeez. I bring this one up because, man, it's not good. It's not always done, and here's where you probably want to make sure you do it. Vacant land disclosure. So on the vacant land disclosure, it talks about sitting water. And this scenario, it was not disclosed that there was sitting water. Well, ultimately, a buyer purchased it, and they could prove that the seller had knowledge of sitting water on the property. There were pictures that were advertised when they previously listed it with sitting water on the property. So again, seller is, man.
But isn't that their due diligence?
He's getting water for you.
Isn't that their due diligence to double check and?
Absolutely.
Again, it's half truths.
Right.
If you see sitting water, you need to disclose it.
Yes, it is a buyer's duty to do their due diligence. I agree. However, it is also by law, a seller has to disclose anything that materially affects value. So when there's a 1 acre parcel and
If they have knowledge of it.
correct, 0.8 acres has sitting water on it, and a buyer can prove, look, you literally have pictures that you listed it with 2 years ago and you owned it with sitting water on it.
On that disclosure, is there a do not know?
Mhm.
Oh, okay.
Yeah, there's the same thing as our
You can't lie about it. If you own the property and it's water on it and you've lived.
Yeah, well, in this case, they didn't even,
I'm selling a vacant land in Denellen and it has some water, but the seller has no idea about the property.
right. And again, they can prove, look, I've never even stepped foot in the state of Florida, so I don't know anything about the property. You know what I mean? And that, again, we have a form for that where you can say don't know. I'm just saying, in this scenario, it was a dead to rights. I can prove that a seller knew about it and failed to disclose it. And that's when things get real ugly. Because that's failing to disclose a defect that materially affects value. So you want to be, again, very thorough when it comes to that. And I, again, will tell you, a vacant land seller's disclosure is a very important tool to utilize as well.
Perfect, thank you.
Can I call a property owner that is listed with a flat fee broker to get the listing?
Okay. No, until it's expired.
What say you?
No.
No.
I was gonna say don't know, but I guess I'll say no.
Join the crowd. Don't run the other way. The answer is no. Again, you cannot solicit business from somebody that already has a listing, whether it's a flat fee or a full, I mean, again, they have an agreement. Now, this is where I'll tell you what you can do, but you have to be very careful with how you do it. So legally, you can give an opinion of value. So you can do a CMA for a customer that is already listed. However, that's where it ends. You give an opinion of value. You don't say, go cancel your listing agreement with Remax and come talk to me. You don't coach them on any of those things. You are allowed to do give an opinion of value. Now, with all that being said, we as realtors typically work with other realtors in this county more than once. So again, I try and keep peace and balance on this earth, in this county, in this industry, without making enemies. So when I have this scenario come up, my answer is you need to consult your listing agreement and that brokerage. Before I do anything, that's the answer that I give. Before I say, yeah, I'll do a CMA for you, they need to look at their listing agreement and consult their broker, that broker. And again, I use the word broker, not agent, because again, that listing is with the broker. A lot of times an agent says things that aren't true, they don't know about, or they need to elevate it to a broker to say, hey, when a customer says, hey, I want out, you know, Jim and I are usually inclined to figure out why, but then let them out. We're not going to be the company that sits there and stronghold somebody into a crazy agreement where, again, we get bashed, the relationship is killed, any of that stuff. I don't know how many times we've had situations where we let a customer out and then they continue to refer us, or they come back and say, all right, now I'm ready to sell. I mean, you just don't know. But if you say, too bad, so sad, you signed a document, or we have a $2,000 cancellation, you're never going to get that business back. You're never going to have that person be a referral for you at all. So again,
Could I say two things
Yeah,
about that?
yeah.
Number one, it doesn't make any sense to me why we would correct another agent's mistake by overpricing a property and giving them a valid amount on a CMA in which they could lower the price and then sell the property and make a commission. That's number one. And secondly, we never want to get involved with another brokerage business. It's called interference, and you can get called on that, and you get in a lot of trouble. So the standard answer is, we need to get this listing expired. We will not make a comment on the property. We will be happy to do so after the listing is expired. But number one, don't give them the ammunition to be able to make a sale, because they probably got the property when it was overpriced, and that's why they got it. That happens to us all the time. So there's no sense in correcting another agent's mistake, and secondly, we don't want to be accused of interference.
Talked about this, but how do I make sure escrow was submitted?
Get the receipt from the title company.
Receipt.
Very good. Can Freck order a title company to release escrow? And again, I've already shared this answer, but we'll go back over it.
No.
And again, I guess I should be more clear. Yes, if the broker is holding the escrow, but in all sake of this question, it was if the title company is holding it. So, which it does say title company. So actually,
You know, another interesting question is if a title company has an escrow dispute, they're not going to release the escrow until they get both parties to agree. And if those two parties won't agree, they turn it over to the courts. They petition the courts to intervene. So that's where it goes. And then it gets to court, and that's when it gets expensive.
yeah, I'm just going to add a little bit because I found this out too. The title company, they don't really make the steps. So like when you have an escrow issue and it's just sitting there, the title company doesn't just say, all right, we're going to go send it to the court, good luck. Like the buyer and or seller starts that buy. And again, it depends on what the contract says. Are we going to try mediation first? Because again, before we litigate or arbitrate, mediation has to happen. So again, in the contract, it states both parties are going to pay their side to pay for a mediator to then mediate the idea. Does that happen? If that is unsuccessful, are we now going to arbitration? So again, there are steps in the contract that states that, but I don't want you guys to just say, oh, we can't agree. The title company is going to be the one that'll issue everything. So, you know, you'll find out a year from now, because that's not entirely true. Now, we've had, I think the longest one that I've dealt with was 8 months. Title company held on to escrow, but it was a little bit different situation. It wasn't necessarily a dispute. It was that we couldn't get a hold of one side of the buyer, whether it was a buyer or seller, I don't remember, but we couldn't get in touch with them. There was no more communication, and we had never met them in person. They were out of state. So it was just, we can't do anything yet.
Yeah.
So any other questions on what we discussed? I know that was a lot longer than we had originally intended, but I thought there was a lot of good
I
information.
have one thing to
Yeah,
say.
go ahead.
I know there's a lot of technicalities and details that you should be aware of, but the golden rule is the real rule. Okay? If you apply that, you'll probably be right. Everybody know what the golden rule is? So, good way to end it. Do unto others as you would have them do unto you. That usually keeps you out of trouble. Just be honest and fair.
I like the addition of the word good. Do unto others good. Because some people use that technique adversely
I understand.
on the negative side. So I don't want to, but I'm just saying, yeah, we want all good results, but the world's not built that way around us sometimes.
Okay, folks, that's it. Have a good day. Wayne's been called out.
You don't know how to do that.
Watch. Come here.